This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to discuss how the Fifth Circuit Court of Appeal dealt with issues relating to who a broker represents and what a court can do when it finds that it is a forum non-conveniens and dismisses rather than advises that the decision as to the issues must be decided in another forum. The Fifth Circuit Court of Appeal resolved insurance issues concerning cable damage in the Arabian Gulf by recognizing the difference between a broker and an agent, the place where and to whom a policy was delivered, and how to deal with the issue of personal jurisdiction, where the district court has over parties, and that a forum non-conveniens dismissal is really not a judgment on the merits, but is rather a determination that the merits should be adjudicated elsewhere. In Dynamic Industries Incorporated et al. Versus Walaa Cooperative Insurance Company and Marsh and McLennan Companies et al., a decision of the United States Court of Appeal for the Fifth Circuit on March 13, 2023, resolved the disputes brought by the parties. The Insured's Dynamic asserted that their insurance brokers, Marsh, failed to procure adequate insurance coverage from the insurer, Walaa, or in the alternative that Walaa breached the insurance policy by declining coverage for an incident involving undersea cable damage in the Arabian Gulf. The district court granted Marsh's motion to dismiss the suit as untimely under Louisiana law. The district court also granted Walaa's motion to dismiss the suit for forum non-conveniens, reasoning that the insurance policy at issue designated Saudi Arabia as the exclusive forum. First, as for Marsh, Louisiana law requires insureds who wish to sue their insurance broker to do so within 1 year from the date that the alleged act, omission, or neglect should have been discovered. This was Louisiana Revised Statute Section 9:5606. Dynamic sued Marsh after Walaa denied coverage, but Dynamic received a copy of the insurance policy from Walaa almost 18 months earlier. When Dynamic received that copy, it also received constructive notice, as far as the Fifth Circuit was concerned, of any deficiencies that the policy contained. Dynamic's claim against Marsh, therefore, was untimely. Dynamic rejected constructive notice, arguing that the policy contains absolutely no indication that coverage would be denied, but the denial was Walaa's choice, not Marsh's. According to Dynamic, the policy either omits coverage that Marsh is liable for failing to procure, or offers coverage that Walaa must honor. For purposes of asserting its in the alternative claims against Marsh, Dynamic asked the Fifth Circuit to assume that the policy omitted coverage. Any such omission was obviously present when Dynamic received the policy, so its suit was time-barred. Dynamic argued that Walaa's policy choice of Saudi Arabia law is unenforceable under Louisiana law if the policy was delivered in Louisiana. Dynamic says that it received delivery in Louisiana from Walaa's agent, a Marsh affiliate known as Marsh KSA. Walaa responded that Marsh KSA was actually Dynamic's agent, and that delivery therefore occurred in Saudi Arabia, where Walaa delivered the policy to Marsh KSA. The Fifth Circuit agreed with Walaa, since Marsh, as a broker, is an agent of the insured, not the insurer. Under Louisiana law, an insurance broker is generally deemed to be the agent of the insured rather than the insurer. A broker who is asked by the client to procure coverage wherever possible at the best price is not the agent of the insurer. Marsh KSA approached multiple insurers looking for a competitive price for Dynamic. Marsh KSA was, thus, Dynamic's agent, not an agent of the insurer. After conducting an independent assessment of the clause's enforceability, the district court properly concluded that delivery occurred in Saudi Arabia to the agent of the insured. Separately, the district court concluded that it lacked personal jurisdiction over a Marsh affiliate known as Marsh & McLennan Companies, Inc. Yet the district court's judgment dismissed Dynamic's claims against Marsh, Inc. with prejudice, that is, on the merits. A federal court generally may not rule on the merits of a case without first determining that it has jurisdiction over the parties, that is, personal jurisdiction. Because the district court lacked personal jurisdiction, it also lacked power to issue a merits judgment regarding Marsh, Inc. Likewise, the district court dismissed Dynamic's claims against Walaa with prejudice. That, too, was an error because a forum nonconvenience dismissal is not a judgment on the merits. It is, instead, a determination that the merits should be adjudicated elsewhere, in this case in Saudi Arabia. The Fifth Circuit, therefore, reversed dismissal as to Walaa Cooperative Insurance Company and Marsh & McLennan Companies, Inc., and remanded with instructions for the district court to enter judgment dismissing Dynamic's claim against Walaa Cooperative Insurance Company and Marsh & McLennan Companies, Inc. without prejudice. In all other respects, the district court's decision was affirmed. And in my opinion, the parties won some arguments and lost others. The case established the fact that an insurance broker is not an agent of the insurer, but is the agent of the insured who, on the insured's behalf, transacts insurance. The district court exceeded its authority, and the Fifth Circuit set it straight, affirmed part of the decision, reversed others, and now the dispute with regard to coverage will be tried in the courts of Saudi Arabia. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can, if you click on that URL, subscribe to the blog and will be advised by email of every issue of the blog, usually 5 a week, sometimes 6. Depending on holidays, sometimes less. You can also subscribe to the videos at YouTube and on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the rumble button at rumble.com. If you found this video to be useful or interesting to you, your colleagues, please tell them about it so that they too can subscribe to the blog and to the videos. And if you like, you might also consider subscribing to my locals community or my Substack publications, where for a small fee you can get extra information on insurance coverage law and insurance claims. Thank you for your attention.